already talked about A and B. So now I want to talk about C, and I'll just read it to you. As we consider the law of torts, it's important for you to understand and to learn that while the law of torts involves civil liability, it's not unusual to find examples of acts that constitute a tort and a crime. If this happens, the person can be liable for the tort and also be found guilty of the crime. The concept of being liable for a tort and being found guilty of a crime for the same or one single act is sometimes hard for people to grasp a hold of. Or sometimes you'd be found not guilty of the crime, like O.J. Simpson.
O.J. Simpson.
He was found not guilty, but he was found liable for the tort, for killing his wife and the other guy.
It's because the burden of proof.
Well, it has a lot, yeah, that's true. Examples of this idea of both. At a downtown bar, Walter drinks to excess. As he's driving home at the last, it should be last, not least intersection, he hits and injures a pedestrian who was crossing the street in the crosswalk and with the light, probably the green light. Walter's blood alcohol level proves to be twice the legal limit. What's the legal limit in California?
0.8.
What?
0.08.
0.08. So he was twice that. Walter has committed at least one tort. It's called negligence, and he will be sued for money damages. And then at least one crime called drunk driving. Now the person who sues him for the tort will be the person that he hit, who suffered the damage. This material is on the material you picked up tonight. You looking at it? You have tonight's material? You didn't get it? Anybody else that didn't get it, now's a good time to get it. When you come in each week, there will be something up here every week for you to pick up. So in addition to signing your name, be sure and pick up the handout. The one who sues Walter for the tort of negligence will be the person that he hit and caused the damage to. The one who sues him for the crime will be probably the district attorney in the county where the crime was committed, or it could be the city attorney. In either case, it's the government that sues for the commission of the crime. Example, another one. If Bob steals Tom's car, then Bob has also committed at least one tort. It's conversion. In other words, if you take somebody's personal property without their consent, you have converted it to your own, and that tort is called a conversion. And he committed one crime called auto theft. Top of the next page. The point is, a person can go to jail for the crime and also pay money for the damages. This is not double jeopardy. Anybody have any questions about this idea that you can commit a tort where you can be sued for your tort and also be arrested for a crime? They're just the same acts.
I think you'd be found not guilty of that same crime, like O.J.
Well, you missed that part of it. The example was O.J. Simpson. Okay. Letter D, if a person acts and commits a tort, he or she may be liable for the damages suffered by the other person or the person involved in the act. Question: what is the form of damages the injured party seeks to recover from the person who committed the tort? What's it called? Money. Money. Damages in the legal sense are awarded in three forms. In a tort action, damages are awarded for three specific kinds of injuries or damages. Number one, special damages. The injured party gets to recover money equal to their special damages. Now, special damages are things like doctor bills, repair bills, medical bills, anything that you can prove with reasonable certainty. And certainly a bill from any of those sources, all you do is show the bill and you have special damages. Then number two, in addition to recovery of special damages, you're allowed the injured party being able to recover their general damages. General damages are for pain and suffering. Yes,
General damages?
general.
General.
General damages. This is for your pain, this is for the injured party's pain and suffering, yes.
What determines how much money would be like a good?
The jury.
They could just be like, oh, $20,000 for this.
With the special damages, they're not likely to do that, they're just gonna follow what your proof is and show, and whatever your damage, whatever special damages you're seeking. Repair to your car, your lost earnings, your medical bills, those kind of things are pretty certain. You don't have to guess at what those might be. And the jury just adds them all up and that's what they give you for your special damages. But when it comes to your pain and suffering, how do you determine pain and suffering and put it in the form of money? Well, it's not easy to do, but it's done all the time because the jury is the one who makes the final determination as to how much money the injured party is going to get for their pain and their suffering. Has anybody ever suffered any kind of pain that resulted in suffering? Yes, what kind of injury did you have that resulted in pain?
I bought a pint of Ben and Jerry's ice cream and had a piece of granite in it instead of pistachio, and it broke out two of my teeth.
Where did it break?
It broke out two of my teeth.
Broke out two of your teeth, so it was in your mouth.
Yeah.
Okay.
That was a pistachio, it was a piece of granite.
Did you get any recovery?
$14,000.
How far did you have to sue? Did you go
There was a
to
class action, there was like a
a
bunch of
number?
them.
Did you have to go to a jury trial, or did they generally?
No, they settled right before.
Did you have to give your lawyer, I assume you had one,
Deposition and all that, yeah.
yeah, did you give your lawyer your medical bills, which would be your dental bills? Okay. And then did you tell your lawyer how much pain and suffering you had, so
Yeah.
that he could tell the jury? Describe to me, or tell me what you told your lawyer about describing your pain and suffering because of this substance.
Unbearable. Tooth pain is the worst pain in the world.
Do you know how people in the ER try to determine your pain when you come in and you tell them you're hurting, and what do they ask you?
Yeah, there's a chart.
Scale of
1 in 10.
1 to 10,
Isn't it with the smiley faces or something
Yes.
like
Yeah.
that?
but it's each smiley face has a number to it, okay?
Yeah,
Now, that's probably the best way of describing what your pain is. And, just to say, I hurt, and especially 2 or 3 years after the incident where it happened, it's hard, sometimes you get better and you forget about it, how badly you hurt. But you have to express that to the jury. And so in your case, you said I was hurting how much? At the
10.
time? A 10.
Yeah.
It hurt really bad.
Yeah.
And then how long did that 10 continue?
For a good 4 days until I could get to a dentist to have my teeth extracted.
And how long did it continue after going to the dentist?
Well, for the rest of my life, I have to wear a partial now for it.
Now, with your pain still a 10?
No.
Well, when did the 10 begin to
Once my
reduce?
teeth were removed and I could no longer use them.
How many days was that?
A week?
It was
5
still
days.
10. It was still a 10.
Yeah.
What were you taking for it, if anything?
A lot of stuff.
Well, then you would be asked what a lot of that stuff is. We won't go into that. I don't want to hear about your alcohol consumption and all that. Okay. So how long did the 10 last? A month? A
5
week?
days.
5 days?
6 days.
And then did it start going down?
Yes.
Where did it go to first?
7.
Okay,
5.
5,
and 3.
okay.
one.
Yeah.
And did it ever get to 0?
Yeah.
And how many
I guess
days-
It never does because I still need my teeth. So.
Well, no, I'm talking about the pain.
Yeah, the pain does. Yeah, it goes to 0.
Okay, and how long did that take?
A month, maybe.
Okay, so you're gonna tell the jury that you were having pain and suffering for this month during this period of time. And you're gonna ask the jury to compensate you for that pain and suffering, in addition to your special damages, whatever your medical bills were, whatever your loss of earnings were, whatever else. And it ended up being $14,000.
Yeah.
And the jury was pretty generous with you. But they can relate to numbers on a chart better than relating to just you saying, I hurt really bad. The third kind of damages that the plaintiff is entitled to recover in some tort cases is called punitive. Now, this one is the one I want you to spell correctly. P-U-N-I-T-I-V-E. Want to write it down? Punitive. Punitive damages, P-U-N-I-T-I-V-E. When I see this written on a test, I get all kinds of words. Sometimes I get puny. You know, well, that's not what it is. Punitive, P-U-N-I-T-I-V-E. You have a problem of the spelling, Mr. Christensen?
No, I don't.
Okay.
I just wanna say the book, it says something about caps on general, damages.
Probably does, but I'm not gonna get that detailed about this subject right now, if ever. Just general damages.
I just wanted, because it was then later said that some states found them unconstitutional, so I don't know why, so there's caps on it.
The caps are unconstitutional, not the damages.
No, the caps are, but it said, yeah,
Right.
there's caps on it, and then later in the book it says they're unconstitutional.
Some
So I
states
didn't
have
know
done
which
that.
one they are.
Sure, why should we put a cap on a person's damages when they legitimately suffered some real harm? You're lucky you only lost teeth. Some people have lost a lot more, and some people have lost their loved ones, and they get to recover under tort law called wrongful death. And the jury has to figure out how much that's worth, and that can take a long time trying to establish what that's worth. So the three kinds of damages in the legal sense that a plaintiff is entitled to recover are, tell me?
Special, general, and punitive.
Special, general, and punitive.
And
Okay.
punitive was what again?
What?
What was punitive damages?
Oh, I didn't complete that, did I? This is punishment. Punishment damages. Punishment damages or punitive damages are only given in a small percentage of cases. And they're only given where there has been an extremely wrongful act by the defendant. Usually, you find these kind of cases where punitive damages are awarded in insurance contracts or insurance companies who have refused to pay on some kind of disability claim, and then in the discovery phase of that claim, they found out that they had meetings and they talked about it, and they were just stonewalling this person, hoping that the person would go away. Well, in addition to the special damages, the general damages, they also got punitive damages. Sometimes manufacturers of automobiles have had to pay some punitive damages.
For punitive.
The tobacco industry has had to pay substantial punitive damages, almost to the extent that it puts them out of business. These are usually big businesses with deep pockets. It's not in the individual cases. Damages paid to an injured party is the way of shifting the loss economically from the person who has suffered the loss to the person who caused it. In the American society, what has developed to shift this risk of loss? By law, when it comes to driving a car, all of us are required to have what? Insurance, and that's what the answer is. We buy insurance to shift the risk of loss. You see, the person who was injured can shift the risk, whatever the loss that they incurred, over to you. And your way of shifting that potential risk is to have insurance. Not only does the insurance provide the legal defense for you, which can be very expensive, but it also can back you up and pay the liability portion of it if in fact you're found to have committed that tort and liable to the other person. It's also a necessary evil, or while it's a necessary evil, the evil part of it is if we didn't have insurance, we'd have very little lawsuits. You understand what I've said there? Most people most, if not all attorneys, the first thing they wanna know is
If he
if
got
the other
insurance.
party had insurance. If they didn't have insurance, their antenna goes down to zero and probably says, sorry, I don't wanna get involved in your case. Because even if they win, they're probably never gonna recover. So the jury gives a big $14,000 award and they can't pay for it. Guess what they do? File bankruptcy and the whole thing's gone. It's been a 3-year process and you haven't got anything. Letter E. The law of torts can be divided into 3 kinds or 3 classes of torts. They are, number 1, intentional, the intentional torts. Number 2,
Unintentional.
the unintentional torts, the unintentional torts. And number 3, strict liability torts.
I was wondering where that one was coming from, 'cause the book only had
Popped up
2.
its head again. Now, letter F. Well, I'll just say it again. Intentional, unintentional, and strict liability. Before we consider in more detail each of these kind of torts, I need to revisit the idea of fault approach to the tort law and help you try to understand what it means. The understanding begins with a definition of the word tort in today's society. It's a fault approach. This is its definition. A private injury arising from a breach of a duty created by law, the breaking of which is the proximate cause of the plaintiff's injury or loss. Now you should be able to turn the page. And keep turning the page. This is just a chart that you can look at on your own time that classifies the torts. That's the next page is the one I want you to look at. That's the one I'm going to work off of for the remainder of the evening. Now, I've just given you the same definition, the fault approach. Number 2, this definition, that's in capital letters up here, contains a lot of words. By now, you should have some meaning to each one of them. So, what do the words private injury imply? The opposite of private is,
Public,
Oh,
so if it's a private injury, what is it?
an injury to an individual?
In law?
That's right. Civil law. It implies that this whole thing is going to be in civil law, not criminal. Letter B. What does the word duty imply? If you have a duty to do something, you also have a what to do it?
Right.
Obligation.
Obligation. So it implies an obligation. Letter C. What do the words created by law mean? Suppose it said created by a legislative body. Or suppose it said created by a constitutional law. Or suppose it said administrative agency. But in this case, it says just created by law. We know the 4 sources of law. What's created by the law? In this definition, read it. A private injury arising from a breach. What's the word breach mean to you?
Breaking,
It's a break. A private injury arising from a breach of duty created by law. Created by law means what? The
Created by the
source,
courts?
the source of the duty. In other words, where it comes
no,
from.
it's contrary to the contract. It's not a contract. That's what it means.
It's the source of a duty. Remember, it's the source of a duty. A private injury arising from a breach of a duty created by law, the breach of which is the proximate cause of the plaintiff's injury or loss. What do the words plaintiff imply?
the naming party?
It's the name of the party seeking money damages. If it said petitioner, then it would be the name of the party seeking equitable relief. But you all know these things, you just haven't yet been able to connect them together. Number 3, today in California and throughout most of the U.S., the law of torts is based upon fault. The fault approach. This means that before a plaintiff can win, he or she must be able to prove the following. First of all, have to establish that there's a duty established by the law. Somebody injures you, and you think they ought to pay. But before they have to pay, the first thing you have to establish that there was a duty established by the law. The second thing is that the breaking of that duty was by the defendant, the one who had the duty. And of course, if he has the duty, what do you have?
Right.
A right. Letter C, conduct of the defendant in breaking the duty was the proximate cause of the plaintiff's injuries. And letter D, injuries suffered by a plaintiff and damages being requested to compensate for the injury. You have to prove your damages. Those 3, possibly. There are 3 categories, classification of torts. Letter A would be what?
Here, what's that?
Intentional.
Unintentional.
Letter B, unintentional. Letter C,
Strict liability.
strict liability. Intentional, unintentional, strict liability. Paragraph 5 on page 2. Intentional, unintentional, and strict liability. The intentional torts, and that's about what we're going to look at for the rest of our time. The intentional torts require the finding of an intent on the part of the defendant. Intent means that the defendant, or the actor, intended the consequences of his or her act, or knew with substantial certainty that certain consequences would result from the act. The law generally assumes that one intends the normal consequences of his or her action. Thus, a push of another person is an intentional tort because the object of the push can ordinarily be expected to move. In other words, the intentional part of it is my pushing you to get you to move. Got it? This is the intent that's required. Just the intent to push you to get you to move. However, this doesn't mean that I have to have in mind that you're going to suffer injury as a result of the moving. If I push another, the defendant pushes another person, and that person trips and falls, hits their head, and causes serious injury, it's no excuse on the part of the actor to say, I didn't intend that to happen. All I wanted to do was get him to move to see the stage. You don't have to intend the consequences of your action. That all you have to do is intend that what you do it for, it happens. But if they do something more and hurt themselves, you're liable for those things. So number 6, intentional torts are generally classified or named as follows. Now remember, we're not talking about crimes, we're talking about torts. Letter A, assault. You ever heard of the tort assault? It's defined as any intentional, see the word intentional? Any intentional, unexcused act that creates in another person a reasonable apprehension or fear of immediate, harmful, or offensive conduct. What freedom is protected by this tort? What right is created by this tort? The answer is we have a right not to expect threatening or offensive conduct by others. We have a right not to expect threatening or offensive conduct by others. What duty is imposed upon the people by this tort?
Can you repeat the first one, please?
What?
Can you repeat the first one, please?
Question is, what right is protected by this tort? Right not to expect. Because you see, by definition, this tort occurs in the other person's mind. It doesn't doesn't occur anyplace else in their mind. You see, the definition, it's an intentional, unexcused act that creates in another person a reasonable apprehension or fear of immediate harmful or offensive conduct. It's what we think in our mind about what somebody else has done. So the freedom that's protected, or the right that's established, is the right not to expect threatening or offensive conduct by others. Do you all feel that you have that right in here? You all understand it's this tort called assault that gives you that right, that protects you, that somebody else can't come along in this room and do threatening acts that would cause immediate fear of harmful action against you? And the question is, what duty is imposed can do nothing intentionally that would cause reasonable apprehension of fear by others. Now, give me an example now of an assault. How could I assault you? What could I do that would put a reasonable fear of harm in you?
Failing me,
What?
failing us.
Well, that might, I don't know whether that's the tort assault. Give me, suppose I have a gun and I stand up here and point it at you. I don't shoot it.
But you have the fear.
Do you see how it would be reasonable to have a fear
Because that is threatening.
of an immediate, sure, it's threatening, of an immediate harm by pointing it at you? Now, if I'm in the other room and I point the gun and you don't even see it, is your fear reasonable?
No.
No, not at all, because you can't even see me. What if I had a knife? What if I had a baseball bat? Bless you. How far away would you have to be before that fear ends and you're no longer feared? The problem is that we have some people that are very sensitive, and they react very quickly to any kind of threatening conduct that other people don't find so threatening. And of course, the jury will have to decide whether or not the action actually was offensive or not. The second tort is called battery. And it's not uncommon that these two torts come together. Battery is the unexcused, harmful, or offensive physical contact intentionally performed. This is the intentional, unprevented touching of another. Where the assault is just the apprehension and the fear of a touching, the battery is the actual touching. Pardon me?
Sorry, but what was the duty imposed upon people by the assault tort?
Nobody, you can't do anything intentionally that would cause reasonable apprehension of fear in others.
Okay.
We come to battery. What right or freedom is protected by this tort? It's the right to personal security and safety. We can walk around in a large crowd and feel comfortable because of this law. The law says others cannot touch us. The question is, what's the duty imposed by this tort? You can't do anything intentionally so as to touch or contact another's body or anything attached to it. You can't do anything intentionally so as to touch another's body or anything that the body is attached to. So you're driving home tonight and you come up to a stoplight, but you don't stop quick enough and there's a car already stopped and you run into the rear end of them. You've committed a battery because the person who is in the other car suffers their personal injury, usually a whiplash kind of thing when you get rear-ended, and you committed the battery, a battery upon them by this touching of their car. It doesn't have to be, you don't have to hit them in a crosswalk. That also would be a battery. It would also be a battery if you hit something that their body is attached to. Now,
This extension of his body.
Right.
Mhm.
Number 3, a typical and usual defense toward a battery are, and the first one is the most important one, consent. You see, in the definition, it starts off, it is a unexcused act. So if you give consent to the touching, then you can't complain about it. What kind of activity might you engage in where you actually consent to touching just by entering into the activity?
Sex.
What?
Sex.
And what?
Sex.
Sex?
Sex?
Yeah.
And the other person consents to it?
Yeah.
So there's unpermitted touching, right?
You said permitted.
It's
You
permitted
said permitted,
touching.
yeah.
Yeah, permitted.
But it's
Well,
presumably,
That was a little different than what I was thinking. Give me some other activities that you might go into. How about football? Now, most of you ladies wouldn't do football, but you understand that by going into football, you consent to being touched in a pretty violent way.
oh, if you're a player, yeah.
That's, you go into it. You go into the game. You can go down to the park on a Sunday afternoon and play a game of soccer.
Because that creates
And
a
you get
standard.
touched, and you consenting to it by being a part of the game. If you're a fighter in a boxing match, you get set, you get your consent, you give consent to being battered, to being beat up.
Yeah, an implied consent.
So, whenever the tort of assault or battery is being alleged, the first defense that comes to mind is consent. Did the person consent to it? Typical factual situation in law school. A young lady is sitting in a park on a beautiful afternoon on a bench by herself, and she's really good looking. This young man is attracted to her, and he walks up and sits down a few feet away, or a few inches away, on the bench. And he strikes up a conversation, and she seems to be responsive to his conversation. And they talk for a little while, and he just moves a little closer. Well, he does this several times, and now he's sitting right next to her. She hasn't said a thing, she hasn't moved, she hasn't acted like he was harassing her, nothing. And they're talking maybe about intimate subjects. We won't go there. They're just having a good time. And somehow or another, he gets the impression that she is going to consent to being kissed. And he kisses her. Well, she falls off the bench, hits her head, has a concussion, and sues him for a tort of battery. Has she consented to the kiss?
No.
Has she consented to the touching?
Does it have to be verbal?
No.
No, it has to be written.
Listen,
It has to be verbal.
listen, it doesn't have to be verbal, it doesn't have to be
Yeah, but it didn't.
guys can tell when a girl wants to be kissed,
Mhm.
period.
It all depends.
I'm just, where do they get that information from? Where did it come from a girl? What tells the best thing about what a girl would want? Their eyes. Men are good at reading a woman's eyes. If you have a girlfriend and she's a little upset with you, you can just tell it in the eyes, and you're not going to go around kissing her at that point in time. And if this is somebody new and you're getting along good together and you're dancing or you're just close together, you can look into that person's eyes, the window of their soul, and you can tell.
Oh my God.
Well, you're,
Is that gonna hold up in court? I said yes.
We know this all.
it was an old case, but it was an actual case. And it's really up to the jury to decide whether or not the man actually thought he had consent or whether the woman had given consent.
I would think in your example, that maybe the consent would be the fact that she wasn't moving away when he was getting closer to her.
That's right, and he got close enough to kiss her and she didn't pull away.
Yeah.
look, you could be,
It really knocked her off her
That's a good
feet,
point.
that's
I would be like,
Get it what?
And then that's why she fell off the bench.
nobody was holding her there, she could have just walked, she could have got up and walked away.
But maybe he was a really big guy, and maybe
She
he
was
was
afraid
kind
of
of
him?
scary, so maybe she was afraid.
But you wanted,
So,
okay.
perhaps she was, you know, afraid.
Afraid of leaving that he might
Exactly.
come after her.
So she didn't give consent, he was just misleading.
Well, that could be, and that would put you a good argument for her, right?
Yeah.
Well, the ladies on the jury are gonna probably have to make this decision. The attorney for the guy is probably gonna get as many men on the jury as he can, rather than women.
So
likely
how
to be
can
a-
they prove the consent? Actually, this impossible.
Just the facts.
But I mean,
I gave you the
oh,
facts.
he got closer. Well, that's
Can't you picture the facts in your mind?
yeah, but
Can't you picture what happened between these two young people? That she got kissed, she was in such a shock, she fell off. Those are undisputed facts, and the facts are not in dispute in this case.
well, probably she
Now
fell
you-
because of some other
that's why-
reason.
That's why the law is an art and not a science. Because you can take those same set of facts, and the plaintiff can mold them into his point of view, and the defendant can mold them, or the attorneys can mold them into their point of view, and it's up to the jury to decide what point of view they're gonna take.
Just by her suing him though, doesn't that mean that there is no consent? Why would she if she's not gonna consent to something?
Well, you
that-
would be on the jury arguing that, wouldn't you?
pair of shoes.
yeah.
I'm not gonna argue with you as long as you have the facts. As long as we have the facts in mind, you can go either way you want to.
So find out what happened. Who won?
She won.
Huh?
She won.
She won.
W-O-N.
Oh my gosh.
So she has to say is that I didn't consent, right?
Well, but her actions always speak louder than what she says, right? And in discovery, we have pinned her actions down by her testimony, exactly what
Her
she
actions
did.
were nothing. She did nothing,
So the fact that she
right?
fell away.
That's what you may say, but the jury didn't agree with you. So live with it.
I think they did. The
Move
girl
on
won,
to the
right?
next case.
The lady won, right?
The lady won, right.
So they agreed with me.
Letter C. The third kind of intentional tort is called false imprisonment. Oh, by the way, I should go through the other.
And what about B?
Letter 3B, the second kind of defense would be self-defense. And the third one would be defense of others and or their property. So the major defense in the intentional tort of battery and also of assault would be consent. You consent to the assault, you consent to the battery. But you can also be engaged in what would be self-defense. So somebody comes up and threatens you, and he takes a swing at you and misses, but you take a swing back, hit him right in the head, he hits the floor and dies. His estate is suing you for the tort of assault, battery. Well, the defense would be, I was just defending myself. And usually that's a legitimate defense. And then we have defense of others, you know, if it was your wife and not yourself, that somebody took a swing at and you come up and try to defend them and these kind of things happen, then you can claim this defense, you're defending others. False imprisonment. It is the intentional confinement or restraint of another person without justification. Another word for justification would be excuse. Question: what right or freedom is protected by this tort? The answer is the right to move without restraint. When a person is confined, I don't care how big of the area is or how small it is, your freedom to move has been taken away. Question number 2 is, what duty is imposed by this tort? You can't intentionally prevent another's movement or activity without excuse. An example of a case where this kind of tort is found would be in a department store arrest or confine somebody for a theft of property. And maybe security officer saw them take something, hide it under their coat, and they walk up to them and say, come with me, I want to take you to an office upstairs. And as soon as that person submits to that officer, there has been, at that point in time, a potential tort of false imprisonment. Now they go further, they go upstairs, they go to the office, certainly a potential false imprisonment. And then, of course, they decide that this person did commit it because they have a video of it. And they decide that they're going to call the police. The police come, put handcuffs on the person, and take them away for a crime. That person also committed, the store could very well have committed a tort of false imprisonment just by confining that person, keeping them from moving. But they had excuse. And the excuse in this case was the fact that the person was committing a theft of their property. But there are some times where people get confined, get put into small spaces of whatever, and there is no excuse. And then we have the tort of false imprisonment coming into play. Then letter D, infliction of emotional distress. It's not uncommon that that people can suffer injuries of their mind. Emotional distress. Now, historically, when the law of torts was first developing, there had to be an actual touching physically in order to get injury for damages in your mind. Emotional distress. But today, you don't have to be touched. You can recover emotional distress so long as you are within, I like to call it, a circle of influence of where the actual act took place. Judy has a 5-year-old daughter that attends a public school down the street from where they live. She's taken Judy to school for the first week of school, and then after that she felt comfortable of letting Judy walk to school. Judy has to cross a street with a cross guard and a red, yellow, and green light. Judy also knows that a little girl gets back home again about 2:30 every afternoon, so she's got it timed pretty well when Judy's going to leave, or when the child's going to leave, and when the child's going to come back. Everything is fine until about 3 weeks down the road, and one afternoon, the little girl hasn't shown up at the designated time, so Judy is a little worried, and she goes out her front door, out to the street, and looks down the street. Just at the time she sees her daughter crossing the street with the crossing guard holding up the sign to hold traffic back. Now, unfortunately, what happened was that a car didn't stop, ran the sign, probably the red light, and hit the little girl in the crosswalk and caused some pretty severe injuries to her. Now, Judy was less than a block away when she saw this. She became so hysterical that they had to call an ambulance and take her to the hospital. And it took several days before she could calm down enough to go home. Now, there is no doubt that the little girl the tort had been committed on her, and the driver of the car is going to be responsible for whatever the damages are. The real question is, can Judy recover her emotional distress even though she wasn't involved in the accident? She sues for emotional distress, contending that this was an intentional act. Driving a car was just the intentional act. And there was some extreme and outrageous conduct resulting in severe emotional distress to Judy. Historically, one could not recover for emotional distress without suffering physical injury or impact. This requirement no longer exists in California. In many states, even so, the incident must generally be horrible, extreme, and outrageous. Judy can recover, even though she was not involved in the accident. Suppose instead of Judy seeing the accident, Judy is at home, the police officer knocks on the door, and he tells her that her daughter's been injured. She's emotionally upset. They have to call an ambulance She spends 2 or 3 days in the hospital. Does Judy get to recover now, even though she didn't see it? Probably so. The further we get away from the accident, though, the tougher it is going to be to convince the jury that, she's still within the circle, where the accident actually is the middle of the circle. How far away are you going to let the circle expand to allow people to recover? And that's up to the jury to decide. Defamation. This is the last tort that this little outline has for us. This is the intentional taking of another's reputation. Circle the word reputation. Now, there are 2 kinds of this tort called defamation. Number 1, this
Libel.
is slander,
Slander, libel.
and it's oral. And number 2, libel, L-I-B-E-L, and it's in the written form. It's defamation in the written form. Before you can understand this tort, you must understand the right that we all have to a good reputation. Our reputation is not what we think about ourselves. That's our ego. Reputation is what others think about us. And as a result, the tort of defamation requires the publication or communication to someone other than who's being talked about or written about. So I'm having a conversation with you, and all of a sudden I start to defame you. No question about it. Whatever I'm saying to you, I'm taking away your reputation. I'm saying some pretty bad things about you. Is that defamation? No. I can say anything I want to you, and it's not defamation. What has to happen is that these things that I say have to be said about you to another person. And it's taking away what that other person thinks of your reputation. You see, the law says we all have a right to a good reputation. And when I start taking away your good reputation, that's what others think about you, I then am committing the tort of defamation. It's got to be communicated or published. Communicated would be the oral, published would be the written, to somebody else. I say something defamatory about you to another. And it's taken away that other person's, what they think about you, and about your good reputation. Now, the most common defense to this tort is truth. I can say all the bad things about you to another person I want to, as long as what I'm saying is true. What right or freedom is protected by this tort? Well, I've already answered it. We all have a right to a good reputation. A good reputation is what others think about us. And let's hope that others always think good about us, especially if they don't know us. What duty is imposed by this tort? Generally, the duty makes us refrain. General duty is to refrain from making false and malicious statements about another, taking away their good reputation. In other words, don't do it. Stop. Refrain from making false and malicious statements about others that would take away their good reputation. What is gossip? Gossip is speaking or writing the truth about another to someone else. You see, if you were speaking a lie about someone else to someone else, that could very well be defamation. But if all you're doing is talking the truth to somebody about somebody else, it's gossip. Now, fortunately, the law doesn't make gossip illegal. But to some of you, you might believe that gossip is wrong. We all have a tendency to gossip. And I guess if we wanted to refrain from gossiping, we should raise our speaking and our writing a little higher than just talking about others. Find something else to talk about than somebody else. Because gossiping really just is wrong, even though it's not recoverable. You can't go to jail and you can't get held liable for damages. Number 5, the right to good reputation is generally applied to private citizens. Compared to what kind of citizens?
Public.
Public citizens. Sometimes private citizens either knowingly or unknowingly remove themselves from the private sector of life and become public figures, and when they do, they lose the benefit of this law. People who start in the private sector but who move into the public sector are, give me some examples.
Politicians.
Politicians. Officials elected to a public office or running for a public office. One of the things that a person who wants to go into politics has to learn and accept right away is that in politics, people are going to say lies about you, period. And there's nothing you can do. You have moved out of the private sector where the law of defamation protects you against those things, and you put yourself into the public sector, you lose your rights that the law of defamation gives to you. Another example would be movie stars. Movie stars are always trying to stay in the private sector, but yet they're always making movies and making appearances. They're moving back and forth. Once they move into that public sector, they don't get the right to have people not say untruths about them. And then sports figures. People involved in sports figures that become, they move from private sector into the public sector in the sports games that they play. And when they do that, they lose the right to have a good reputation. People can say lies about them. We know in sports figures, generally, if somebody starts talking about them, they'll just climb up and won't talk. They won't do interviews, they won't do anything. Movie stars have a lot of trouble not doing that because it's the interviews that actually lead to their fame. Now, what's the trade-off when a person moves from one public sector or private sector to a public sector? Money. Fame and wealth. So anybody that's likely to move into any one of these activities needs to consider what they're giving up compared to what they're trying to gain in deciding either one of these activities. Now, on your way out tonight, pick up a handout that I want you to work on this week. Finish reading chapters 12 and 13. And tonight we'll have test number 3.